we got.
Ma'am, good morning. Can you please state your full name and date of birth for the record? Ms. Boone is seated at council's table wearing a light gray suit and a white blouse. She is in custody, however, will not be wearing any restraints. As such, we will continue to stand when our jury enters and exits. We're here for a charging conference. The court has reviewed, I believe, both parties' red lines as to the jury instructions, including, I believe, that was submitted last night, the defense's red line as to the jury instructions that were provided by the court. Let's try to get as much done as we can until our jury arrives. I believe what we had discussed yesterday was starting at the beginning and moving through as quickly as possible until we get to the real meat of some of the issues in the 3.6F and the 3.6G instructions. Mr. J?
May I remain seated during the charge conference?
Yes, sir, you may. Thank you. All right. I have in my hand a 34-page document that was emailed to the court last night by counsel for the defense at 12:06 a.m. from Lauren Henderson. That's what the court's going to be relying on. Does everyone have that in front of them?
Yes, sir.
Defense.
And basis, yes, Judge, I think.
Okay. All right. Let's start on page 1 of 34. 3.1, Introduction to Final Instructions. Any objection to the form of this instruction state?
Now I'm confused. I don't know that I have a 34-page document from them last night. There was an attachment. There was an email at 12:06.
Hang on. Let me make sure.
36F, separate red lines, 36G, separate red lines, 8.9, culpable negligence, red lines, separates.
Give me a moment. Then it was what was sent at 11:31 yesterday.
That 34-page document I have.
Okay.
No, 31. I don't know if it's 34. It says 31 to me.
I have it as 34. Okay.
Excuse me, Judge.
Yes, sir.
Can I have Ms. Henderson explain how she sent the document?
Fine by me.
No, I didn't. What was I supposed to hear?
Instructions from the defense based off the document you had sent to us yesterday morning. And then last night we approached and I had asked if that format was okay for you. I believe Mr. J had said, could the defense send separate 3.6, 3.F, so it'd be easy to incorporate in your final instruction.
And that's what was sent at 12:05 last night. All right.
Just for more convenience for you.
Understood. Okay.
Thank you.
But the balance of the instructions, because that just addresses those.
I'm sorry.
What you just advised only speaks to the 3.6, 3.6G instructions.
And F and culpable negligence.
Correct. Okay. All right. So I'm talking about the balance of the instructions that may or may not be at issue.
Yes, sir. That was the balance of instructions that are not at issue. Those are what was sent at 11:30.
Okay. All right.
My confusion is the court is indicating they have a 34-page document.
Yes, sir.
I have a 31-page document that was emailed to us by Ms. Henderson at 11:32 in the morning.
Are you looking at October 24 at 11:31 a.m.? Subject, defense proposed jury instructions in red line format?
I'm sorry.
No worries. I'm looking at the email correspondence of October 24, 2024, 11:31 a.m. Subject, defense proposed jury instructions in red line format. Is it possible that you don't have your track or track changes are off and maybe that's why? That's the difference.
Where the track changes.
In Word, under review, or I can just have Madam Clerk print out 2 more copies. And we could just work our way through that.
Quick track changes for everyone is still only 31 pages.
Okay. I just forwarded to Madam Clerk. I'm gonna have her print out 2 copies. That way we've got hard copies, so we seem to be all on the same page.
Any objection?
All objections.
Can you please state your name for the record, ma'am?
Not
Okay, thank you.
scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got preacher on the dial, planning always make your chap smile. The pros say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day on Law Talk with Mike. Courtroom is always popping off. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing off. We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure to appear and you scoff. Judge Simpson is never going soft. Webster is always showing hard. We are heading into. There is no scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike.
All right, both parties have provided the court yesterday a 34-page document, which includes the defense's red line with regard to the proposed jury instructions. We'll start on page 1 of 34. Instruction 3.1, Introduction to Final Instructions. Any objection to the form of this instruction, State?
No, Your Honor.
Defense?
No, Your Honor.
Moving to page 2 of 34, Instruction 3.2, Statement of the Charge. State?
No objection.
Defense?
No objection.
Moving to page 3 of 34, 7.1, Introduction to Homicide. Those 3 paragraphs, any objection?
No objection from State.
No objection.
Moving to the next portion, Justifiable Homicide in the singular paragraph. Any objection, State?
No objection.
Defense?
No objection.
Moving to Excusable Homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3. State?
No objection. I have no objection to anything I submitted to the court.
Okay, thank you. Defense?
No objection.
Moving to page 434, 7.4, second-degree murder instruction. Defense, any objection to the form of the instruction?
No objection.
And also the removal of the lesser included chart on page 5 of 34, correct?
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser included crimes or attempts. My only question is, if I understand from the defense, they're looking to see culpable negligence is a lesser included.
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this, the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read the lesser crimes, plural, indicated in the definition of second-degree murder is manslaughter and followed by culpable negligence.
Yes, so it should go to R. Yes.
State?
State objects. There's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. Both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser of manslaughter, it's a category 2 lesser, which includes by inference, there must be some evidence that her culpable negligence did not result in death.
What's your response to that?
Judge, the instruction that we're asking for is 8.9. it reads to prove the crime of culpable negligence. The state must prove the following two elements beyond a reasonable doubt. One, Sarah Boone exposed George Torres Jr. to personal injury. And two, she did so through culpable negligence. As to the fact that there is evidence of culpable negligence as to the case, and the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. The defense can get category 2 lesser included offenses as long as there's evidence to support the category 2. And there is evidence in this case to support the category 2 lesser included. That's
And
what I'll ask you.
any other further argument, Mr. J?
No, Your Honor, thank you.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of George Torres was caused by the culpable negligence of Sarah Boone. So how can you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? I'm logically having trouble understanding that.
Because this is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of culpable negligence. The difference is, and I think the burden is different from the state, because it's not alleged in their information.
Does not the instruction say give 2A, 2B, and or 2C depending upon allegations and proof?
Yes, the allegations would be the information.
Okay. Any response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that. The language does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a prior fact to reach that this was out of culpable negligence, and if they reject our argument that it was done knowingly and not hatred, ill spite, etc.
Any other argument, sir?
No other argument.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final 2 paragraphs of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be George Torres, is not applicable. Is that correct, state? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, sir.
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence.
With regard to the
Second lesser?
second lesser? Yeah, thank
No
you.
objection to that proposed instruction.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only?
Yeah, we would request to add it, the culpable negligence, since it's going to be given. So it should read second degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second degree murder, manslaughter, or culpable negligence.
Yes,
correct?
Your Honor.
Thank you. Any objection, defense?
I agree with that.
Thank you. Do we want to take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get not
This-
3.6 done.
At this time, just going to make a note that we're going to bypass the 3.6F instruction and 3.6G instruction. That'll take us all the way to page 23 of 34, instruction 3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plead not guilty?
Did I skip it?
Yes, sir, page 23 to 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I didn't, I was just making sure that there were no edits that either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable? State.
Yes, Your Honor, I agree that 8, the inconsistent statement instruction should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page, state?
No, sir.
Defense?
No, Your Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included the requested language by the state. Is there any objection to the form of this instruction at this time, defense?
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning?
Yes, please.
Okay, so I'm going to read you the entire 3.9B instruction. 3.9B defendant statements reads, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you, or to this instruction rather. Thank you. The last sentence read, if you conclude the defendant's out-of-court statements was not freely and voluntarily made. You should disregard it. Any other clarifications to that instruction statement?
No, Your Honor, thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put whether Sarah Boone's statements
Where are we specifically, sir?
in the state special that I have no objection to? It says, this is however one of the factors you may consider whether the defendant's statements, if we could have Sarah Boone's statements, were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10? Defense? Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30 the 2.7 closing argument form instruction. Any objection to that instruction state?
No, Your Honor.
Defense?
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34 state.
No objection.
Defense?
No objection.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agree.
Okay, all right. Is this instruction acceptable to the state?
Yes, Your Honor.
Wait, are they sending the suitcase back? I couldn't quite hear him.
Defense?
Yes, Your Honor.
They all are. That's how it works.
And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict or the instructions. I'll have Anita clean that up and send it to the parties so that we have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form, and it looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out, and it was just culpable negligence.
Under the defense's part, yes.
Right.
Yes.
Okay. So how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, it certainly needs to be included in the verdict form.
I understand, Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. Is that acceptable to the state?
Yes, Your Honor.
Is that acceptable to the defense?
Yes.
All right. Similarly, I'll have Ms. Barrios make those revisions and submit them to the parties as soon as possible. Anything else, state, we need to address before? Bruce, do we have everybody as of this time? Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's request for other instructions, which I think we'll have to table for now,
Yes, sir.
are we prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court and the defendant's attention was apparently yesterday at lunch, there was some sort of domestic violence event out in the quad. The coworker indicated that without believing it was any particular jurors in this case, that he did see people with juror badges in and about the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates. Was utilizing, but I do have an issue.
Yes. What do we got?
I think the state attorney, the last piece of evidence is they they extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce messages which they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out. And under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what they're planning.
Mr. J, any response?
It's going back with them, just like I told them during some of the body worn cameras. Only some of it's published. It's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have a scrub laptop. You're going to do review it all.
Okay. Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
Again, I'm not sure how long it's going to take. I do not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers do not publish them.
Anything further, Mr. Owens? Okay, all right.
On that issue, I would like to take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely shouldn't suggest what it
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
Yeah, I don't know what that is. If somebody knows, put it in the chat. Poppy, you say?
behavior in this case is disgusting.
Challenging it
Okay, in what way?
in a good way.
Anxiety leads to constipation.
Jack it up.
2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for counsel, starting with counsel for the state.
David Castro on behalf of the state. William J. for the state.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone is still seated at counsel's table. Are we ready to go ahead and bring in our jury at this time? State.
Yes, sir.
Defense.
Yes, sir.
All right, let's stand and bring in our jury.
If you didn't know, y'all stink. Okay, that's just my opinion.
The wheels of justice are going to roll you right into the Wayne County Jail.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you. Yesterday, there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
What do you mean by observe?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right. Record reflects no hands have been raised. Did anyone see anything during that event? All right. Juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the parties approach for a moment?
Because your petitions, whoever has drafted it, they don't know how to draft it, draft the petition properly.
All right. Members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible. Thank you. You all may be seated. Thank you. Juror in seat 2 on the first row from right to left. You had advised, based on the court's question, that you had observed something. You said, what does observed means? And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch, and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror, I don't want to say her name.
Okay, all right. Is that a juror that was on our panel here?
Yes.
Okay, all right. Do you recall where they may have been seated?
No, in the back over there.
Okay. All right. Do you recall what color her hair was?
Yes.
What,
No, let me tell you.
please.
Dark brown or black.
Is it the shorter juror? Okay, thank you very much. State, any further questions?
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I couldn't hear anything, no.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial? Yes. Thank you.
Can the parties approach for a moment? We appreciate you, ma'am. Thank you so much. We're going to go ahead and bring in the balance of the panel. You can just hang out where you're at, okay? We stand for you. You do not need to stand. We stand for you. State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury. All right, y'all can be seated. Thank you. Again, members of the jury, if I can see those hands, you complied with the instructions during that really short break. Record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from States 21, which was previously marked as P for identification.
You may proceed, sir.
Again, this is a DVD exhibit with two folders in the main directory. One entry is in a folder called Attachments. Another is a PDF labeled Extraction. And for the record, it is 108 pages, and the entire document will go back to the jury, and there will be a laptop provided to them to utilize this exhibit. For purposes of publication, I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name, the contact if one exists, or the phone number if one doesn't. On page 1, creation time for notes, 7:49, asking Jorge or George not to be despicable to me, making more drink after he guzzled his and I shared mine. On page 2, date March 8th, 2018. You are now in a relationship with Jorge or George on Facebook. Metadata entry 100014, etc. for Jorge Torres to Sarah Boone, owner. Page 3, May 21st, 2019, from 407-716-8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow. page 9, May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407-716-8684, which I will just refer to as owner in future references. Where is my clippers in the gray box? From owner to Mom Jorge, all capitals, dumpster, separate message, like you, separate message, so is your 2 shirts, separate message, no more Rick and Morty, a response from contact Mom Jorge to owner, okay. From owner to Mom Jorge, Lucas cried when he saw the adventure fund was gone, thank you, no wonder you're out, fuck off. From owner, he's the one that broke it because you took it. From owner, wanted to go on an adventure. On to page 10. From owner, be proud, feel good. You made my, quote unquote, our son cry. Cheese stick, Lucas, your kids, get the fuck out of my life and my sons. No one, spinster, good, for nothing, dumpster diver, that's what you are, and the rest of you. Later on this same page, owner to Mom Jorge, get, all of you, mean, selfish, fuck all you, your firstborn is a joke. Going on to page 11, same date of May 30th, 2019, from owner to Mom Jorge, get the fuck out of my life. Lucas 2, bad influence. From Jorge to owner, I am, as you can see, go drink your life away. From owner to Mom Jorge, your kids are too. Yuck. Shucks, I only have 1. Beaters, your 3 together. Yuck. Going on to page 12, from owner to Mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy. You're the one who kicked me out. Owner to Jorge, Mom, finally. Get your shot together and check me out in 2 to 3 months. Hope you're there. Unless I find someone better. Shit. Together. From Mom Jorge to owner. Are you serious? Owner to Mom Jorge. That's what happens? No. Mom Jorge to owner. I'm helping out Dad right now. Call you in a few. Owner to Mom Jorge, can you help me put out, fuck off? Jorge, Mom to owner, how? No problem. From 267-216-5170 to owner, damn. You can only talk when you're drunk and talking shit. Owner to the previously mentioned 267 number. Stop calling, texting my phone. He's not here anymore. And it's damn. 267 number to owner. NP, you didn't have to be a bitch about it. Owner to 267. Going on to page 13. Still May 30th. 2019. Yo, I like you all. He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you. 267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night. Owner to the 267 number. Friends forever, thank you. Would love to chat sometime. Call his parents, I guess. Further down on page 13, now on to May 31st, 2019, from owner to mom, Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate. Until then, if he wants those back. And I have your quote-unquote art box. Mom, Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear. Owner to mom, Jorge, you're a liar. I never can believe you from all the other lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom, Jorge to owner, I'm not lying. Owner to mom, Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours. Mom, Jorge to owner, I didn't take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to mom, Jorge, go for it. Bring mine, W. Mom, Jorge to owner, I don't have anything of yours. That's why I'm coming with them so they can vary that. Owner to mom, Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom, Jorge to owner, they seen what I had in my hands. Owner to mom, Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom, Jorge to owner, exactly. Owner to mom, Jorge, you were a visitor and a terrible resident, boyfriend too. Just go away unless you bring my stuff. Mom, Jorge to owner, I don't have your shit, Sarah. I need my birth certificate. Owner to mom, Jorge, I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine. Mom, Jorge to owner, whatever, Sarah. Owner to mom, Jorge, next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom, Jorge to owner, whatever. Owner to mom, Jorge, it's been a great day without you. Will be from now on. Mom, Jorge to owner, you need to do. Owner to mom, Jorge, enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before. Owner to Jorge, mom, did you take Lucas's sunglasses? Mom, Jorge to owner, OMFG, no, I did not. Turning to June 2nd, page 15, 1:10:57 a.m. from owner to mom, Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo. (1:18, 16 seconds on June 2nd. Owner to mom, Jorge. I beat you to the punch. Want to do the dartboard with me? Come. Owner to Mo. I know you won't answer, Mo. Tell him to come finish the dartboard with me, please. Owner to Mo. I miss him. Owner to mom, Jorge. Ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m. Can you have Jorge call me, please, when he gets a chance if he's with you? 7:45 a.m. Owner to Mo. Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo, hello, can you please have Jorge call me? Willing to give back. Don't know if he's there or at parents. Really want to see him. Owner to Mom Jorge at 10:52, 16 a.m., not pursuing after 12 o'clock, ever again. (12:19 p.m., 23 seconds, owner to Mom Jorge, please call, come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please, need. You. 6:23 p.m., owner to Anna, he doesn't live here anymore. Call parents or Mo, in response to an incoming phone call that was made at 6:10 p.m., 54 seconds, from Anna to owner. Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic, captured 6:33:01 p.m. Image 0093 HEIC, captured 6:33:26 p.m. Publishing from attachments. Image underscore 0092, metadata showing 6/2/2019, 6:33 p.m. And image or IMG underscore 0093, metadata, date taken 6/2/2019, 6:33 p.m. (6:34 p.m., 51 seconds, June 2nd, 2019. Outgoing from owner to Mom Jorge. All up to you now, big boy. And for the record, those images were sent to Mom Jorge at 6:34 p.m., 33 seconds. Look what you made me do. Or maybe your mom will for you. Response from Mom Jorge to owner. Wow, that's really childish. Owner to Mom Jorge, but effective. Mom Jorge to owner. Yeah, I see what you are doing. Did Lucas leave? Owner to Mom Jorge. I'm watching shadows. Be gone for good. Minus birth certificate. Mom Jorge to owner. Okay, cool. Enjoy. Owner to Mom Jorge. Am. Nice. You're not. And nice was from Mom Jorge to owner. Going on to page 17. This is still June 2nd, 2019. Mom Jorge to owner. Yes, I am. You are not, though. Owner to Mom Jorge. To who? Your mom? Brothers? Not me. Mom Jorge to owner. To everyone. Owner to Mom Jorge, but me. Mom Jorge to owner. I love you. Owner to Mom Jorge. I'm going out at 8. Get dressed. I've given you since noon. Peace out, Boy Scout. Mom Jorge to owner. I'm coming over with a handle. I was helping Pop all day cut grass. Owner to Mom Jorge. Yay you. Getting in the shower then out. Bye-bye. Mom Jorge to owner.
Excuse me, can we approach the bench?
Yes. Objections overruled.
I'm already showered and dressed. Mom Jorge to owner. Hello? Text from Anna to owner. You're rude as hell, but okay. Owner to Anna. Your dad is a POS, but okay. At least you know and will stop calling. Owner to Anna. Futile. Anna to owner. CTFU, as you are a piece of shit, but that's God's business, not mine. Have a good day, coke whore. Since you like to switch it up, I'll do the same. Don't text me back either, fake ass. Page 20 of 108, June 9th, 2019, from owner to Philip. He's off the lease. The process has begun. Page 22, June 11th, 2019. Metadata only shows to Mom Jorge. You tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly fucked up face around here again. Police will be called. Ask him if it was worth it and ride my bike he has. Stay Hispanic, that's what you all are. And he can watch all the porn he wants from the phone Mom gave him.
Exciting and new.
Page 26, June 14th, 2019, 11:38:56 p.m. To Mom Jorge. Wow, congrats, blackouts and whoring. We wanted to see him. Hot house, 7 people. Mission to work on my bike. Repeat. Candy Crush. Fuck himself. Shit job. Repeat. Same page, June 15th, 2019, 7:37 p.m., 48 seconds. To Melissa, just an FYI, if my place gets effed up, I'm letting you know. He's in jail. Thanks for the prompts. I'm at my ex's house. Please don't let this reflect on me as a tenant. You said to call cops. I did. He's gone. We're both proud now. I consider you my friend. Melissa, why was he in your apartment? Page 38, notes, creation time, June 26, 2019, 5:56:57 a.m. 6:14, X videos, 10:03 a.m. Sarah Banks, 5:3 Bank, 6:13, Metro activation 6:12. Skipping down, X videos, 6:2, 6:13 p.m., X videos 6:1, X videos 5:31, 9:56 Who's Christine? Paren FB. Going to meet up? Question. Calling her beautiful? Question. Said she thought you were avoiding her when down here. Said no, I was not beautiful. FB-nonchalant Quay. Thanks for adding me. You are exquisite. Facebook messaging Camille 6:13, 9:42. Facebook or FB Pamela Erickson sending pictures of yourself, telling her good morning 7:14, 12:13 a.m. FB-Crystal going to woo her, sweep her off her feet, going to change her mind. Luck is my middle name. Sent her pics, kiss emojis, called her beautiful after returning to the convo. Said you had to pick up your brother, sent pics of beer, sent her struts, could have been me, sent her songs but not me, messaged bunny kiss emojis, convo, sent puppy kiss emoji, would love to take her out and see a movie, told her about what we do in the shadows, would love to watch Creed 2 with her, want to snuggle with her and eat popcorn, sent heart-hugging animal emoji, want to play a board game with her, asked to FaceTime call her, called her amazing, messaging at 7:30 6:14, 6:15, 2 days. FB-Crystal liking all her posts, quote, losing someone who doesn't respect or appreciate you is actually a gain, not a loss. Can't compare me to the next girl because there is no competition. I'm one of a kind and that's real. Continuing on to page 39, same note. I found everything on your phone, all your messenger texts, telling Christine you want to meet up with her when she's here, calling her beautiful, thanking nonchalant Quay for adding you and calling her exquisite, telling Pamela Erickson good morning and sending pictures at 12:38 a.m., messaging Camille, then the whole 2-day convo with Crystal, how dare you, and send pictures wearing my wedding ring. You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up, or I will, since I have your phone, and log in and tell everyone why you were in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore. I want nothing to do with you ever again. I've become a different person since you've been gone, with less stress, anxiety, and worry. I feel safe, comfortable, happier with you not here or seeing you at all. I can say through I do have heartbreak after going through your phone. Thank you for always proving me right. I knew when you told me your mom gave you one that you'd be back to your slimy ways. You will never change. I hope it was all worth it, all of it, including losing my debit card for the 3rd time to buy beer and cigarettes, which put you back where you belong. I know for a fact you were not worth any of it. I just can't believe after everything I've done for you, including all I did to get you out of jail, and you do this to me. This is cheating. Goes on to page 40, goes on to page 41, and ends with never truly yours. Page 42, June 26th, 2019, 8:06 p.m., 16 seconds. Outgoing from owner to Mo. Just wanted to let you know to tell Jorge I found all his messages, kissy face heart emojis with Crystal and other bitches on FB, along with all his porn after he swore to me he wasn't doing any of that anymore. I'm not doing anything more for him, and he will try and keep him in jail as long as I can. Cheating snake weasel. Ask him all about it or have your parents the next time they talk to him. I'm not anymore. So hurtful after all I've done for him. He can rot in there for all I care. Going on to page 43, to Mo from owner, and I will be there for the hearing next week and his arraignment on both charges. Peace out, fucks, aka Torres. Same page 43, from owner to Mo, 6/26/2019, 9:59:14 p.m. Begins, hi, I was thinking if you could get out, I'd really love it if you'd take me to a movie, or we could snuggle like we do and watch Creed 2, get some popcorn and pretzels, maybe talk about what kind of other movies we like, or find a fun board game to play together. I know your favorite is Avalon. What do you think? I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear.
Yes, but it's too late for that.
But what I really miss are the kissy love emojis you would send.
You don't need
because
motive
I
anyway.
really miss those, especially the ones with hearts. They'd always make me smile. I knew you were thinking about me. You do Crystal, though. Even asked her to FaceTime. What would you do if you found me having this convo with Ben or John or anyone other than you? I'd be beaten to a bloody pulp. And don't do any of these things anymore, but yet you wear your wedding ring and mine around your neck and tell me how much you love me. But you're telling this woman who looks like TPT you want to snuggle with, take out to a movie, play board games with, questions, sending music, cutesy, kissy love emojis to like you used to me, telling her you want to woo her, sweep her off her feet. How do you think that makes me feel? Why don't you say that to me? Going on through the rest of page 43, page 44, including on page 44, dirty cheat, enjoy your porn and jerking yourself off secretly so your parents don't see you and your ugly new girlfriends. I can't wait to finally be with a real man, Ben, who will and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow. Now you really are. You're despicable. Next text is XOXO from Mo to owner. Page 50, 6/28/2019, 10:55:47 p.m. from owner to Mo. Just know I can do so much more damage than all of you put together. Know that. Going on to page 51. Try me. Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner. No metadata, but from Janice. Sorry it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but was quite bummed out that he overslept. But I was okay and told him, no problem, just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered, so I have no idea where he is or what he's doing. What happened last night, he had a black eye. He said it was new because I asked him and I told him to put makeup on it. He said he had that taken care of. Did you two get in it again? He acted like when I told him he had a black guy, at first he didn't know what I was talking about. I guess he kind of blacked out. You can call me back if you want. (11:30 p.m. 38 seconds) from owner to mom, Jorge, Janice just called me looking for Jorge and she's pissed. Congrats. Page 82, 8/21, August 21st, 2019. From Jorge to owner, I love you, my friend, my love, my queen, my everything. Now that concludes everything I'm going to publish to the jury on this exhibit.
Okay.
Judge, will we approach this?
Yes.
Number one, know what I'm saying? Number one, know what I'm saying? We are the Law Talk with my crew. Number one, know what I'm saying? 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 Trial. This is crazy. Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore? I never want to hear it again. Sweet Jesus. You're not a whore? Not a whore? You're not a whore? I never want to hear it again. It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
Can you just let this go for once? For once? Once?
Okay, that being so.
Mr. Sharts. Not a whore?
Mr. Sharts. Mr. Sharts. Mr. Sharts.
Everybody's looking down. You're not a whore? You're not a whore? I never want to hear it again. You're not a whore? Jack it up.
Members of the jury, thank you for your patience. I just have a short instruction to read to you. Members of the jury, the state showed you portions of what was entered into as State's Exhibit 21. It is not the entirety of State's Exhibit 21. The entirety of State's Exhibit 1 will go back to you into the deliberation room with a laptop for you to review all the exhibits and text messages and the total conversations over and above what was highlighted by the state. With that, State, do you have any other witnesses, evidence, or testimony to provide?
Your Honor, at this time, the state rests its rebuttal case.
Okay. Anything further from the defense? You want to approach?
I just think we have some issues outside the presence of the jury that we need to address.
Okay.
I have one thought, though, that requires a quick approach.
Come on up.
Judge Simpson will tell you that being a no, we just have one question, are you a hoe? Mrs. Short, so Mrs. Short, so where did you go? We have questions like on the weekends, do you work selling burritos? The law talk with my crew, we're here to laugh at you. We see you in court acting all tough. Your soul says citizen life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And Your Honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, we're here to laugh at you. We see you in court acting all tough. Your soul says citizen life must be so rough. And now Kinky Kelly is shacked up in bed with the fruit bowl. Then the cat jumped on his wiener and started causing trouble. Love exciting and new, we are and always will be. The law talk with my crew. The law talk with my crew. We see you in court acting all tough. Your soul says citizen life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And Your Honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, here to laugh at you. We see you in court acting all tough. Judge Simpson will tell you that being a no, we just.
All right, members of the jury, we're going to go ahead and excuse you for a couple minutes. I got some things I have to discuss with counsel outside of your presence. We'll bring you back in for additional instructions on where we think we're going to go after that. Similar instruction that I've given you over the last couple of days. Please do not conduct any independent research or investigation with regards to the persons, places, things, or charge involved in this case. And do not have any discussions amongst yourselves or anyone else about them. We'll bring you back in as promptly as possible. Thank you.
I am moving out of the house. I'm closing on a house right now, hopefully within 2 to 3 weeks. I do have a storage unit. I've been moving stuff out.
So when are you going to have vacated the premises?
Well, I'm hoping within 2 to 3 weeks, I'm in.
Attention on putting on a sir rebuttal in this case, sir. Yes, sir.
Judge, we do not intend to put on a solo level for the defense.
Okay, thank you. All right, Ms. Boone, I've got a couple of questions to go over with you, ma'am. You were previously sworn this morning. You've had the opportunity to review and participate in the trial. You've had the opportunity to review the rebuttal case as provided by the state. You've had the opportunity to review and listen to that evidence and witness any cross-examinations as it relates to the state's witnesses in their rebuttal case. Are you satisfied with your attorney's representation of you in this matter?
Definitely.
And are you still on board with the strategy that has been utilized in your defense?
Yes.
Now, your lawyers yesterday told the court that they may want to put on a sir rebuttal, which would be a limited rebuttal to the evidence presented by the state in their rebuttal, both yesterday and today. Your lawyers have indicated that they do not intend on doing that. Similar to other conversations we've had, ma'am, I don't want to know specifics. I just want to know if you and your lawyers have had these conversations. Have you had a conversation with your attorneys about putting on a sir rebuttal or a reply in response to the state's rebuttal?
Yes.
You had that conversation?
Yes.
Are you on board with the strategy employed by your lawyers that they are not seeking to put on a sir rebuttal in this case?
I am.
Okay. All right. Is there anything else that we need to address? State.
Yes, sir. Judge, you remember you were going to say?
Yes. Thank you, sir. Ms. Boone, at the conclusion of the state's presentation of State's Exhibit 21, Mr. Owens had approached and had advised the court of some objections, specifically with regard to the co-ownership or co-usage of the phone. The court is not permitted to comment on the evidence, and your lawyer was seeking an instruction from the court to advise our jury that both you and Mr. Torres had access to that cell phone. I am prohibited from commenting on the evidence. Now, that doesn't prevent your lawyer or the state from speaking about that in their closing arguments. Just as a matter of law, I am not able to advise the jury as to what that evidence is. The second request pertained to the state moving from place to place through those 108 pages, moving from timestamp to timestamp. The state chose to present that evidence in that manner, which is why I gave that instruction to the jury that not the entirety of Exhibit 21 was provided to them as to what the state produced, and they'll have to have the opportunity to review that in its entirety when they go to deliberate. Do you have any questions about that so far?
So far, no.
Okay. The last portion, ma'am, pertained to the cadence or tone in which you and Mr. Torres communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what the tone was behind those words. Your lawyer advised me that there was an objection and you had some concerns as to the way Mr. J may have read those text messages to the jury. I found that the way that he read them was benign in a flat tone and did not exacerbate or excite any of the language that was in there. He'd read them in as a monotone way as possible in presenting to the jury, and I didn't notice any changes in his cadence or heightening or lowering in the volume or tense or tone utilized in presenting that information to the jury. Do you have any other questions for me, ma'am?
No.
Anything else we need to address, Mr. Owens?
No, sir.
Anything else we need to address, state?
No, sir.
Okay. How would we like to proceed with the charging conference? Do we want to bring back on our jury? It is 10:33 and advise them this is when we think you want to come back because we're going to be addressing the law to provide to you, and that's something I need to do outside of your presence. How do we want to proceed at this time?
I think hopefully at 10:33 to about noon should do it for 3.6F. It is convoluted, but I think the parties have narrowed it down to really just a couple of things.
Okay.
So I would suggest saying something along the lines of, we have to finish up getting the jury instructions ready for you. That's something that we have to do now after the evidence is concluded, and we'll see at 1.
I say 1:30, Judge, in the abundance of caution, because, Mr. Henderson, I know this is gonna be an issue. And it's gonna take a little bit of time, and then we wanna go to lunch and give them a chance, because there's gonna be a 3-hour speech session. I don't know if you give them a break in between prosecutor's statement and my statement, or how you do that.
We may, depending on just the time of it.
But from 1:30, that's gonna go to 2:30, 3:30, 4:30. So just before 5, I think that's plenty of time in case he goes a little bit longer, or I go a little bit.
And I still have to read the jury instructions as well. So I mean, with 34 pages, and I read quickly, as Madam Court Reporter will advise me.
Are they gonna have to
Yes.
be reading along with you?
Yes, so once we make all these changes, every member in the box will have a paper copy. You, Mr. Owens, and your team, along with Ms. Boone, will have a copy. The state will have a copy. Madam Court Reporter will have a copy, and I will. And I will read line by line, all the way up into the 2.7 instruction. At that point in time, I will stop. I will advise our jury that we're going to begin with closings. State will go, you will go, state will have an opportunity for rebuttal, and then I'll finish with the verdict and final instructions. Discharge our alternates at that time. I'll go back and thank them and give them their jury certificate forms, and then we'll release the jury. I'll have a final colloquy with your client, and then we'll review all the evidence to send back, with the exception of the baseball bat.
And perhaps in case they haven't inferred, let them know that they're getting the case tonight, so make plans to stay later.
Yes.
How late are you gonna keep them?
9 o'clock is the norm. I may, because it's the weekend and it's Friday, I may seek special dispensation from the chief to stay longer. I plan on communicating with the chief during the lunch hour as to that issue,
I think that would be great.
if she'll let me. I don't know if it's at her discretion. I know I have to seek approval after 7. I'm not worried about that. I know, and I would prefer them to work late into the evening if they're on board with doing that, rather than coming back Monday. Okay, all right. If you all would be so kind to give me a moment so I can go back up to chambers, get with Ms. Barrios, and I'll give paper copies of everything from the revisions that we made this morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather us waiting on them than them waiting on us. So I think 1:30 is the way to fly. Let's go ahead and bring back in our jury.
And this is why I don't do trials. Yet here I am.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated. Members of the jury number 2 in the back, he's ready. He gets it. All right, can you raise those hands one more time for me? All right, record reflect, hands have been raised as compliance with regard to the court's instructions. Members of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided to us over the last week. At this point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30. At that point in time, the court will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are any plans or things that you need to reach out to, as we discussed last week during jury selection, that we could work till late as 9, and we may work later than that this evening. If there's anyone that has any concerns as to working that late, please raise your hands at this time. Court sees no hands.
Oh, thank you.
I would also ask of you, if you
I feel
could,
guilty.
please reach out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they won't have phones.
Yes, we will provide you, the court deputy will provide you the emergency phone number when we get back from lunch, so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not you must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your attentiveness, service, and sacrifice. We'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
with the parking, we're going to be here for some time. Can we leave and come back and get restamped with a new thing?
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right. Thank you very much.
All right. I'm not hanging out for this nonsense. Thank you. You guys are too sweet. All right. Just because I'm cranky, you don't have to be nice to me. Seriously.
Okay.
All right. We're going to come back at 1:30
I've been
Eastern,
advised by, you know what?
12:30 Central.
Could you just tell me what it was? Say it for the record, what it was.
Judges,
I don't care about their charging conference or whatever nonsense they're doing. It's just going to be that defense attorney objecting to everything. At least they don't have to do a sidebar because the jury's not there. But it's going to be a lot of whining. It's going to be mostly this. You know what's coming. Plus, I've got a hearing. So I'll take care of the hearing, and I'll be back here, bright-eyed and bushy-tailed, ready to roll at 12:30 Central, 1:30 Eastern. Oh, thank you, Andrea. Aren't you sweet? All right. I will see you guys in a little bit. We are making progress, though. This actually, the pace of this trial has been pretty darn good. And last night was interesting when they got to the videos, and even the reading this morning was good. Just confirming what we already knew. She's a nasty bee. All right. I'll see you guys. Whoa, I'll see you guys in a little bit. Well, thank you. Thank you. Oh, here we go. Here we go. I hope she doesn't see this. All right. I'll see you guys in what? An hour and 45 minutes.